Welcome to the Personal Injury Law Show, viewers. My name's Tony Carbone, personal injury lawyer with 25 plus years experience. Next to me I've got Nunzio Tartaglia, one of the youngest partners in the law firm.
Tony Ellis, how are you, viewers?
And on the other side I've got an up-and-coming superstar, public liability lawyer, Alice O'Kane. How are you, Alice?
I'm fine, Tony, and yourself?
Yeah, very good, thank you. Very good.
So, Tony, what's in the news this week?
Look, there's been a lot in the news, but the story I want to highlight is the one involving a young prospective mother, 28 weeks pregnant. She's having stomach and abdominal problems. She rings up the midwife at the local hospital she was attending, and she said, look, you might have labour pains. So she goes from her work to the Royal Women's Hospital. They do an internal examination on her. They check her out thoroughly, and they said to her, look, you might be constipated. They give her some medication, send her home. 2 hours later, she gives birth to a stillborn baby in the toilet. It's just unbelievably outrageous.
Horrific.
Now, the thing that astounds me is that it's a hospital that's got a ward that deals specifically with births, and she would have been fully dilated, you would have thought, for her to give birth.
That's right.
So I'm still...
What should have they done, Tony?
Well, the part that really astounds me is the fact that she said, I think I'm having labour pains. And the midwife at the other end of the phone said, you might be having labour pains. But they totally discounted it. They should have done probably an ultrasound or further testing.
At least some sort of investigation.
Yeah, of course.
Because the baby was still alive at the time, from what I understand.
Of course. So it's very tragic. The other one, just quickly, was the young girl that went in with appendicitis at the Casey Hospital. They sent her home, went to the GP, gives them a letter, sends them back to the hospital saying it's appendicitis. They sent her home saying it's gastroenteritis. Eventually her appendix burst and she had to have emergency surgery, and she's been coming in at a hospital for the last 7 weeks.
And is that open surgery as opposed to keyhole surgery?
It is, and she's got a very, very nasty scar.
For a girl that age, it's
awful,
terrible.
isn't it?
But it just shows you, I mean, it doesn't matter who you are, complacency kicks in, or, I don't know, maybe carelessness. It's just very disappointing, I guess. We've all got to be a bit more vigilant, no matter who we are. Look, viewers, tonight's topic is glassings in pubs, clubs, restaurants. It's under occupiers' liability laws. Nuns, tell us a bit about what this topic's about.
Well, basically, this topic's about, I suppose, the duty of pubs, clubs, bars, or any entertainment venues, with regard to incidents such as glassing and what their general duty is, and whether, I suppose, they've got an obligation to prevent these things. It's a very controversial topic because how far, should it go, and what's their duty, Tony? And
what governs the responsibility of these pubs and clubs?
Generally, Tony, in Victoria, it's the Wrongs Act, so it's all organised by statute. And the Wrongs Act says generally about any kind of venue, whether it's a pub or a club or even a restaurant, that they have to have a duty to keep their premises safe. And that includes many different things, but the controversy with this topic is that we're not really sure of the extent of how safe a pub or club needs to be when it comes to glass or when it comes to incidents involving alcohol.
Well, in Victoria, we've also got the Liquor Control Act 1998 that deals with responsibilities of pubs and clubs in terms of how they serve liquor. For example, they've got to provide adequate controls over the supply and consumption of liquor. Now, just whilst we're on that topic there, we'll go to the first case, which is Scott and Motor Accidents Insurance Board in Tasmania. Now, this is a very, very sad set of circumstances. Who wants to give me the facts?
Well, Tony, this is a very tragic case, as you say. Mr. Scott rode on his motorcycle to his local pub where he knew the publican well, and when he arrived at the pub, he said to the publican, I'm going to give you my keys because I plan on having a few drinks tonight. It's going to be a big night, and at the end of the night, I'm going to want to drive home on my motorcycle. So please keep the keys away from me and help me get home by a different means. And Mr. Scott went on to do exactly that, to get quite drunk. He was, I think, found to be about 0.23.
0.25.
0.25, yeah. That's right. And he rode his motorcycle home, and on the way home, unfortunately, ran off the road and was killed.
Sadly, when he gave the publican the keys, Mr. Scott got agitated and said, give me my keys back, and I think he felt threatened and he handed them back.
Yeah, that's right.
You don't do things like that, do you?
Well, definitely not. I said in this day and age, I said that's a bad move. I said all it took was one cab charge and to say go home and sober up and pick up your car tomorrow, your motorbike tomorrow.
In the first instance, he won his case, didn't he?
No, he lost first up, then he won on appeal, and then he lost at the High Court.
So
right, he had a bit of
he
a
lost in
yo-yo
the first
time.
instance.
He lost in the first instance.
On what basis?
Well, basically, they said that the club didn't have a duty, I suppose, that the licensee or the pub did not have a duty to protect him with relation to the consumption of alcohol and, I suppose, the consequences that flow from that.
Okay. And what happened in the Court of Appeal, Alice?
In the Court of Appeal, they found that, in fact, the pub did owe him a duty of care. They had a bit of extra knowledge at the beginning. You know, he said he was going to get drunk, and then just because he got a bit aggressive, the publican gave in, and so then they found that he was entitled to damages as a result. But unfortunately, the High Court didn't agree.
And this was the partner's case?
That's
the
right.
wife's?
That's right. His wife brought
dependency.
the case on his behalf.
Now, in the High Court, he lost.
He lost. Look, basically, the High Court said that, you know, he's responsible for his own actions and that there's not much more the pub or the licensee could have done at the time. Look, I find it a little harsh.
I reckon it's outrageous.
To put it blankly, yeah. Look, as I said before, all it took was a cab charge, and if you gave it to him, he would have been home safe.
Well, there was only a few people in the actual pub at the time.
That's
and he
right.
specifically went in there and said, hey, take my keys, I'm going to get sloshed tonight. He said that.
That's right.
Basically, do so many words.
And then all of a sudden he gets aggro. Why didn't he give him the cab charge or ring up the wife?
That's all he should have done.
Or given him a lift home?
That's
Because
right.
it sounds like he wasn't too far away. He only went a few hundred metres or so before he ran off a bridge and killed himself.
It's extremely tragic, Tony.
It sort of doesn't make sense because they say you should take personal responsibility for your own actions, but when you're you're
In that
intoxicating
state,
in a state,
inebriated
well,
state.
How can you? So
That's right.
It's sort of a double-edged
Definitely have
it's a
less
double-edged sword.
responsibility.
Look, what's important is that the Chief Judge French Court said that what's critical in these cases is to look at the actual statutory provisions of each state, and I would have thought that if you applied the liquor licensing laws here, coupled with the Wrongs Act and Section 14B, you'd be able to show that there was a breach of statutory duty causative of injury.
That's right.
So I think in Victoria would be finding
In common
liability.
law, it'd be difficult, but under
That's right.
statute, we might have a different
You might have
case.
a way in, that's right.
All right, let's get on to Modbury Triangle and Ansell. This is a case that's been a thorn in everyone's side. Tell us the facts.
That's right. Well, Tony, with this case, there was a fellow who was an employee at the Modbury Triangle Shopping Centre in South Australia, and he, after shutting up one night, went out to the car park to drive home, and he was assaulted by 3 unknown patrons in the car park. The lights were off, it was dark, and his argument was that it was very dangerous and that the shopping centre could have done more to protect him.
Well, this went first instance, Court of Appeal, and then the High Court.
And again, the High Court didn't find in the plaintiff's favour, and found that there was no duty on behalf of the shopping centre with regard to this incident.
Why?
Said that they should not be responsible for the criminal acts of a third party.
That's right.
And despite the fact that they were on notice about the need for the lighting at the time.
Look, we'll come back to this after the sponsors break. Viewers, please don't go away. We'll be back very shortly. Thank you.